Greetings, ladies and gentlemen. My name is Eidel Faliq, student ID 03718849. In this presentation, I will examine to what extent contempt of court in the form of scandalizing the judiciary fairly restricts freedom of speech in Malaysia. Scandalizing the court, also known as scandalizing the judiciary or scandalizing judges, is a form of contempt of court consisting publication of statements which attacks the judiciary and likely to impair with the administration of justice. Traditionally, the justification for this offence is that courts must be protected from attacks that may weaken judicial authority and the rule of law. However, freedom of expression is also a fundamental right in many democratic societies, including Malaysia. Article 19 of the Universal Declaration of Human Rights affirms that everyone has the right to freedom of opinion and expression. Although Malaysia did not ratify the Universal Declaration of Human Rights, as a member of the United Nations, Malaysia has an obligation to uphold the spirits and letters of the UDHR. Most importantly, freedom of expression must also include the freedom to criticize the judiciary. In Malaysia, courts possess constitutional and statutory powers to punish for contempt, such as Article 126 of the Federal Constitution and Section 13 of the Courts of Judicature Act of 1964. Subordinate courts also possess similar powers under legislation. However, contempt of court in Malaysia, including scandalizing the judiciary, remains uncodified. As a result, Malaysian courts continue to heavily rely on inherited English common law principles. This creates uncertainty, and an unclear law contradicts one of Lord Bingham's principles of rule of law, which is laws must be clear, accessible, and predictable. Because the offence is judge-made, the boundaries of lawful criticism remains unclear. Lord Panic, for example, famously argued that public confidence in the judiciary should be earned through integrity, transparency, and quality judgments. This concern became particularly significant in the federal court case of Peguam Negara Malaysia versus MalaysiaKini.com, where an online news portal was held liable for contempt based on third-party comments posted by readers. The federal court relied on Section 114A of the Evidence Act of 1950, which presumes that online platform owners are publishers of content appearing on their platform unless proven otherwise. This decision was criticized because it creates a chilling effect on freedom of expression. Because of that, online platforms may fear liability for user-generated comments and may therefore over-censor discussions or disable public comments entirely. Malaysian Bar argued that Section 114A reverses the ordinary burden of proof and threatens online speech and democratic discourse. Therefore, this presentation argues that the uncodified and judge-made nature of scandalizing contempt in Malaysia creates a vague and unpredictable legal boundary. In this section, I will examine the legal test for scandalizing the court in Malaysia and whether mens rea or intention is required to establish liability. The leading case is Murray Hibbert versus Chandra Sriram. In this case, the appellant, a journalist for the Far Eastern Economic Review, published an article called "See You in Court," which commented on a pending defamation suit and included criticisms of the Malaysian judiciary. Contempt proceedings were brought against him, and the High Court found him guilty and sentenced him to 3 months of imprisonment. On appeal, the Court of Appeal clarified the governing principles of Malaysian contempt law. The court confirmed that the correct legal test is an objective test. It is sufficient if the publication is likely or tends to interfere with the administration of justice. There is no requirement to prove actual interference or actual damages to proceedings. Instead, liability arises where the publication creates a tendency to interfere with justice, prejudges issues, pressures the court, or undermines public confidence in the judicial system. This demonstrates that the Malaysian contempt law operates in a broadly preventative manner. In effect, it approaches a form of strict liability because even where the publisher acts in good faith or without intention to cause harm, liability may still arise if content is considered contemptuous. On the issue of mens rea, the court made it clear that the intention is not a required element. The relevant question is that not whether the author intended to interfere with justice, but whether the publication viewed objectively would have that effect. This position is reinforced in earlier authorities such as Public Prosecutor versus the Straits Times Press Limited, where the court held that intention of the writer is less important than the effect of the words on an ordinary reasonable reader. This leads to the adoption of the ordinary reasonable reader's test, where the court asks how an average member of the public would interpret the publication as a whole. Similarly, in the case of Lim Kit Siang versus Datuk Sri Dr. Mahathir Mohamad, the court emphasized that the test is not whether a judge's feeling is hurt, but whether public confidence in the judiciary is shaken. Taken together, those cases establish that the modern Malaysian approach is the real risk test. Under this test, contempt is made out where there is real substantial risk that public confidence in the judiciary will be undermined. The focus is that whether there's potential impact rather than the subjective intention. However, this approach has been subject to criticism. First, although the test presented as objective, critics argue that it is ultimately judges who decide what an ordinary reasonable reader would think, which introduces a degree of subjectivity. Second, because intention is not required, the law may have a chilling effect on freedom of expression. Journalists, commenters, and the public may self-censor legitimate criticism because they fear that it could be interpreted as contemptuous. Third, the threshold of real risk or tendency may be considered low, as it does not require proof of actual harm to the administration of justice. As a result, while the legal test is designed to protect the integrity of the judiciary, it also raises serious questions about proportionality and the extent to which it fairly restricts freedom of speech. Now let's look at the federal court decision in the case of Peguam Negara Malaysia versus MalaysiaKini.com, commonly known as the Malaysian Kini case, which represents a modern and controversial application of contempt law in the digital environment. In this case, 5 users posted comments under a news article published on Malaysia Kini's platform. These comments were alleged to have scandalized the judiciary by suggesting misconduct and corruption. Although the comments were authorized entirely by third parties, contempt proceedings were brought against Malaysia Kini as the platform operator. The federal court imposed a fine of 500,000 ringgit, holding the platform liable for contempt of court. This decision is significant because it extends liability for scandalizing contempt beyond the original speaker to the digital intermediary. In other words, the law no longer targets only the person who makes the statement, but also the platform which facilitates its publication. This marks a structural expansion of contempt law, shifting it from a direct expression to a platform-based liability, which fundamentally alters how freedom of expression operates in online spaces. The courts relied on Section 114A of the Evidence Act of 1950, which presumes that the platform operator is the publisher of content appearing on the site, unless proven otherwise. This is legally significant because it reverses the ordinary burden of proof. Instead of the state providing publication and responsibility, the platform must prove it was not responsible for that act. From a constitutional fairness perspective, this raises concern because criminal or quasi-criminal liability is being imposed without requiring clear proof of intention or knowledge. This shifts the law closer to a form of strict liability in the context of involving freedom of expression, which is traditionally treated with higher protection. The impact of this framework is that it's not limited to punishment in individual cases. More importantly, it creates a systematic chilling effect on digital speech infrastructure. Many platforms will respond by pre-moderating all comments, heavily filtering criticism, or disabling comment section entirely. This means the effect is not just that the individuals are deterred from speaking, but that the structure of public disclosure itself becomes more restricted. Therefore, the Malaysian Kini case illustrates or tells us how scandalizing contempt, when combined with statutory presumptions like Section 114A of the Evidence Act of 1950, can disproportionately restrict freedom of speech under Article 10 of the Federal Constitution. The key concern is not merely that speech is restricted, but the restriction may be disproportionate and indirectly imposed through platform liability rather than direct author accountability. Historically, the United Kingdom also recognizes scandalizing the court as a part of contempt law. However, a significant turning point occurred following the European Court of Human Rights decision in the case of the Sunday Times versus United Kingdom in 1979, which emphasized that restrictions on speech must be proportionate under Article 10 of the ECHR. Subsequently, the United Kingdom enacted the Contempt of Court Act of 1981, which codified sub judice contempt and introduced a strict liability rule limited to cases involving a substantial risk of prejudice to active proceedings. Importantly, even after codification, the offence of scandalizing the court remained at common law and was increasingly viewed as outdated. This culminated in its abolition under Section 33, subsection 1 of the Crimes and Courts Act of 2013, following a Law Commission recommendation that the offence was vague, unnecessary, and incompatible with modern free speech standards. Analytically, this reflects a clear policy choice that the judicial authority should be protected through legitimacy and reasoned judgment rather than criminal punishment of criticism. New Zealand, on the other hand, took a different but equally reformist approach. The Law Commission identified key problems with the old common law system, including inaccessibility, ambiguity, and incompatibility with the digital age. As a result, New Zealand enacted Contempt of Court Act of 2019, which fully codified contempt and abolished the common law offence of scandalizing the court. The statute replaced it with more clear categories of contempt, including publication affecting fair trials, disobedience of court orders, while explicitly allowing fair criticism of the judiciary. The significance here is that New Zealand did not abolish contempt entirely, but instead it prioritized legal certainty. This reflects a balance between protecting the administration of justice and safeguarding freedom of expression through clearer boundaries. Canada shows us a more rights-based approach. In R versus Kyopto, in the Ontario Court of Appeal, held that the offence of scandalizing the court was incompatible with Section 2, subsection B of the Canadian Charter of Rights and Freedoms, which guarantees freedom of expression. The court emphasized that courts must be open to robust criticism, even if expressed in harsh or impolite language. It famously stated that the judiciary is not fragile flowers that requires protection from controversy. This demonstrates a strong constitutional stance where freedom of expression is constitutionally entrenched. Vague common law offences like scandalizing contempt cannot survive unless they meet strict justification standards. Singapore, on the other hand, had retained scandalizing contempt but replaced it with clear statutory footing under Administration of Justice Protection Act 2016. The Act defines contempt categories and includes defences for fair criticism. However, it still criminalizes statements that risk undermining public confidence in the judiciary. In Attorney General versus Wam Kok Han Jolovan, the Court of Appeal confirmed a risk-based test, focusing on whether a reasonable person would perceive a real risk of undermining judicial integrity. This reflects a more interventionist model where the freedom of speech is recognized but more tightly regulated in the interest of maintaining institutional authority and public confidence. Taken together, these jurisdictions illustrate three distinct models. The United Kingdom and Canada move towards a more greater freedom of expression, either by abolishing or constitutionally striking down scandalizing contempt. New Zealand, on the other hand, seeks legal clarity through codification, ensuring limits between lawful and unlawful contempt. Singapore, on the other hand, maintains structured but restrictive control through statutory codification. Finally, I will discuss the recommendations and possible reforms for Malaysia regarding contempt of court in the form of scandalizing the judiciary. The Malaysian Bar has taken a clear position that Malaysia should reform its contempt framework. This includes abolishing the offence of scandalizing contempt, repealing restrictive provisions such as Section 114A of the Evidence Act of 1950 and replacing it with current common law-based system with a modern Contempt of Court Act, basically codifying it. The central philosophy behind this recommendation is that judicial confidence should not be maintained through punishment or suppression of speech. Instead, it should be built through transparency, integrity, consistent quality of judgment, and reasoning. In other words, a strong judiciary does not require silence from the public, but rather the ability to withstand criticism. This approach is also consistent with human rights standards such as Article 19 of the Universal Declaration of Human Rights, which recognizes freedom of expression, including the right to criticize public institutions. Although Malaysia has not ratified it, these instruments reflect a global trend towards stronger protection of speech. As Lord Panic famously stated, legal ideas does not stop at passport control. What this means is that constitutional principles, especially those involving freedom of speech and expression and judicial independence, are not confined within national borders. Instead, common law jurisdictions continually influence one and each other in shaping how contempt law is regulated. This can clearly be seen across different jurisdictions. The United Kingdom abolished the offence of scandalizing the court through the Crimes and Court Act of 2013, recognizing that the offence was vague and no longer compatible with modern free speech standards. New Zealand went further by fully codifying contempt through the Contempt of Court Act of 2019, which replaces old common law principles, which is very uncertain, with more clear statutory rules. Singapore, on the other hand, provides a different model. It retains scandalizing contempt, but codified it under Administration of Justice Protection Act of 2016. Although fair criticism is allowed, the court still apply a broad risk-based test to determine whether public confidence in the judiciary is undermined. This comparative analysis shows that there is no best single approach, but there is a clear global tension between protecting judicial authority and safeguarding freedom of expression. In Malaysia, the current reliance on uncodified common law and statutory presumptions, such as Section 114A, creates uncertainty, as seen in the Malaysian Kini case. Liability may extend beyond the actual speaker to the intermediaries, which raises concerns about how it creates chilling effects on online speech. Therefore, Malaysia faces a key choice. It may follow the United Kingdom's approach by abolishing scandalizing contempt entirely, or adopt a Singapore-style model by codifying and clearly limiting its scope. However, which direction is taken, reform is necessary. The current framework risks being overly broad, unpredictable, and inconsistent with the constitutional guaranteed rights under Article 10 of the Federal Constitution. Ultimately, the goal is to ensure that contempt law protects the administration of justice without unnecessarily restricting legitimate criticism in a democratic society. Thank you.